welcome to the attendees that are joining us. So we've got Miriam and Susanna with us so far, and Dawn's just joined us. Brilliant. So people are getting on, it looks like. So that's fantastic. If you can hear me, that means your sound is working, and we will get started in a couple of minutes. So we've given other people a chance to join also. Alrighty, I think people are still joining us, but in the interest of time, it is 11 o'clock, so I will get started. And for people who are still joining us, that's okay, because there's a sort of 5 to 10 minute introduction from me anyway. So I think if people are still sort of getting onto the webinar and signing in, etc., or if it's anything like me, actually, when I open Zoom up for the first time in a long time, updating Zoom. But by the time people have managed to get back on with us, I'm sure we'll have more people here to listen to Peter, and his presentation is going to start in about 10 minutes anyway. So rather than wait for people, I will crack on and let people join as I'm introducing the webinar as a whole. So welcome to today's webinar. I'm really looking forward to it. It should be a very interesting topic from a very knowledgeable speaker. Before I hand over to Peter, I will just introduce myself. I will tell you my name because it's not on screen. My name's Alison Bonathan, and I am a technical manager at CIPFA. So very warm welcome from CIPFA today. In case you're not sort of au fait with who CIPFA are, CIPFA dates back to 1885 and is the only professional accountancy body exclusively dedicated to public finance in the world. So CIPFA trains and regulates accountants. We do things like standard setting in the UK. We train quite a lot of local authority accountants in how to prepare financial statements, etc., for local authorities here. Internationally, we do a lot of work with donors, partner governments, other accountancy bodies, and various other stakeholders in the public sector to enhance public financial management globally. Our international team have got a wide range of programmes and advisory activity going on with those partner organisations. So, for example, the programmes delivered by CIPFA's international team include some of the following. So the professional accounting qualification is our sort of, that's the programme that I was just referring to for, that's our chartered accountancy programme. And there's a whole host of other programmes and credentials that are tailored to the very specific needs of the different professionals in the public sector. So wide range of programmes that you can train in with CIPFA. And the international advisory, oops, sorry, the fade's a bit funny on that, apologies, that's yeah, it was meant to all be purple, never mind. So some of the advisory work that we do is, as you can see, capacity development of professional accountancy skills. I'll give you a second to just give that a bit of skim read. So as I say, all about developing capacity for public financial management globally, because we are committed to best use of public funds. The programme that I wanted to talk to you in particular about today, just to introduce you to CITFA and what we do in this space, and because Peter's going to talk to us about whistleblowing and raising concerns. The programme that we're developing at the moment that sort of aligns with that most closely is our corruption prevention programme. Now, this is a really exciting programme that we're about to kick off a pilot with. Actually, next week is the first real activity that we've got going on beyond the sort of planning stage that we've been involved in for quite a long time. So we are developing a corruption prevention programme that I think is going to talk to us about shortly. So the corruption prevention programme, it's a little bit different in that it does contain a qualification, but it's not all about the qualification. It very much is a holistic programme with various different parts. So we think that corruption prevention, corruption's been described as a cancer, hasn't it, by people like Kofi Annan. So we want to really strengthen capacity for corruption prevention in the public sector globally. And we're doing this by developing a programme that aligns with UNCAC, the UN Convention Against Corruption, and UNODC guidance, UN Office on Drugs and Crime guidance on corruption prevention. UNCAC Chapter 2 in particular requires signatories to work to prevent corruption in their countries. So the corruption prevention programme that we're designing is about helping the public sector within signatory countries, which is almost all countries, deliver on their obligations to reduce corruption and prevent corruption under UNCAC Chapter 2. And we think this is going to be more possible. Obviously, we're not, we know that corruption is not just going to go away overnight. However, we've got like kind of a three-pronged approach. Firstly, we've got a code of practice for people for public sector organisations to sign up to demonstrate and make public their commitment to corruption prevention. We've got an executive briefing programme for very senior leaders across the public sector, so that they understand, what their responsibilities are as senior leaders and how they can help practitioners throughout the organisation who are likely to be at more operational levels, how the senior leaders can help those practitioners to fulfil their duties with regards to corruption prevention, what support needs to be put in place for them, what sort of communications need to go up entity-wide, etc. And then finally, we've got an international certificate on corruption risk management, which is a qualification that we are designing. And all of the sort of delivery elements, so the executive briefing and the ICCRM, the qualification, are all underpinned by an ongoing community of practice approach to continuing professional development. The ICCRM in particular is going to try and add capacity for corruption prevention professionals within public sector entities by training them in, firstly, the theory behind corruption prevention. So we look at things like the fraud triangle and how assurance can assist in prevention of corruption, how a corruption risk assessment differs from assurance, this kind of thing. And then and then the second half of the qualification is more about a practical approach. So which tools can a corruption risk assessor use to do a corruption risk assessment with a working group in an organisation? How can corruption prevention plans be rolled out and delivered on in an organisation, etc.? Much more practical towards the end of the qualification. Now, of course, if you are interested in that qualification, please do let CITFA International know with you. On to today's main focus. As I say, I wanted to talk to you about the ICCRM and the corruption prevention programme because it links very strongly to what Peter is going to talk to you about with regards whistleblowing and raising concern. So Peter is our speaker today. Peter is a professional certified accountant and trainer for microfinance banks, directors, management and staff in Nigeria, and a financial management consultant to corporations, institutions and international NGOs. Peter's a faculty member of the Financial Institutions Training Centre in Lagos, Nigeria, and the Equipment Leasing Association of Nigeria. Peter holds a BSc in economics from Obafemi Awolowo. Sorry, excuse me, I did.
You try.
Thank you, Peter. I will owe a university in Nigeria and an MSc in economics from the University of Lagos in Nigeria. Apologies for that, Peter. I did practice that before I spoke aloud, and obviously my nerves got to me. Peter's an insightful and experienced consultant, an impact trainer and facilitator with over 30 years of work experience. His areas of emphasis are training and financial and management consultancy. He's experienced in developing training courses, materials, guidelines, manuals, and other educational materials. In his subject matter, his subject specialism of whistleblower mechanisms and approaches to case management for misconduct and speak up culture. And I think one thing I'm particularly interested in hearing about from of a whistleblower case that is cited in his presentation. So I can't wait to hear a bit more about that, because Peter has got that real hands-on experience. So it should be a fascinating presentation. I'm looking forward to it. In terms of questions and answers, Peter's presentation is going to last for about an hour. After which there will be opportunity for question and answer. On today's Zoom, there is a Q&A panel. So you could keep a note of any questions to the end of the presentation, or you could pop them in that Q&A panel as they come to you so you don't forget. Either's fine, but there will be about 20 minutes for Q&A at the end. So please do think of those questions that you want to ask. On that note, I'm going to stop my video and hand over to our speaker for today, Peter.
Thank you very much. I really appreciate you. I welcome all participants, our colleagues, the invitees to this webinar. And I think all of us owe it a duty to appreciate CIFA for this kind of training. We have 1 hour, as you have been allotted, for this webinar, after which there will be question and answer for 20 minutes. The real objective that we should get on set for this training is that we have all agreed in Africa that if we don't get corruption, then corruption will kill us. And again, when you fight corruption, corruption will fight back. And the idea of whistleblowing is just as a tool to curb this corruption in Africa. So we have 4 outlines, 4 sections to cover under this webinar. The first one is the introduction. The second section is what is whistleblowing, the origin and what we mean by it. And section 3 will be looking at the management of whistleblowing. How is it being managed? And that area will be so critical to us because we discovered that people fear or shy away from whistleblowing today because they have not mastered the idea of managing it. That's why we'll be covering what concerns are to be raised, what are the steps for raising concern, what are the prerequisites, what should you focus on when you are raising concern, and what are the reporting channels when you are raising concern. Then you have forms of reporting. And lastly, we'll be zero it down to African case study. We will look generally at African country and we will talk about Botswana and Nigeria in this case. What is the objective of this webinar? To engage with public sector professionals on the importance of updating professional knowledge and skills on whistleblowing and raising concern. And because some of us professional colleagues may not know that our duty demand that we raise concern, not if we like, no matter whatever be our fear. If we fail to raise concern, to whistleblow, and it backfire, it can land anyone into jail. Again, to provide an overview of whistleblowing and help public sector professionals exercise professional judgment and obligation or when to whistleblow in a multitude of business scenarios. It's either we are to whistleblow or we are to even receive, we are going to receive the whistleblow. And again, to gain understanding of the issues and laws surrounding whistleblowing, and we'll be able to share experience on whistleblowing in Botswana and Nigeria. What is whistleblowing? Let's look at the origin. The sailors are the first set of people that talk of whistle. And they do this when they need a wind to free a becalmed ship, so they blow the whistle. But the first set of people to actually be labeled as whistleblowers are the US police. And why do they blow the whistle? They blow the whistle to attract attention to wrongdoings in the case of US police. And as for us in Africa, you are familiar with Republic of Benin. You agree with me that the police there still blow the whistle when there is any wrongdoing, particularly the traffic offenders. Now, what comes to your mind when you hear of whistle? If you are a lover of football, you are a Manchester lover or fan, you are a Chelsea fan, the first thing that will come to your mind is the referee when you hear a whistle. And if you have been a member of Boy Scout or Boys Brigade, you know that it comes to your mind the issue of whistle. So also the hunter and the guard. The referee blow the whistle when there is a foul play. The essence of going through this is to give us a background of what, without being too technical about whistleblowing, that when there is an issue, there is an intruder, there is an attack of armed robbery, then you hear the guy blowing the whistle. It's to call the attention of the residents. And it's similar to the idea of the whistleblowing we will be discussing under this webinar. A referee will blow the whistle when there is a foul play. All these are linked together in the idea of whistleblowing. Generally, what is meant by whistleblowing? Generally, whistleblowing is the disclosure of misconduct or wrongdoing in the context of work-based relationship. But the reporting must be to a designated channel to constitute a protected activities. This is just general definition. Individual country, particularly in Africa, as is our focus, individual country has got an act or a provision in a legislation that will define who is whistleblower and what is whistleblowing. But generally, from onset, let's have that mindset that whistleblowing is just the disclosure of misconduct or the wrongdoing in the context of work-based relationship. It is making disclosure in the public interest. And of course, when a member of staff raises a concern about danger, impropriety, or illegality that affects others, for example, colleagues or members of the public, this is important and critical. It must affect the member of public. What are the concerns? Under the management, we have whistleblowing management system. And let us really concentrate on this idea. It saves us ASUS. It saves us from running into problem, from the much noise that the whistleblower always run into. I give you an example. We will have shown it, but because of our time, we'll have shown a video, and probably Alizine or Lorraine might send it to participants later, of Michele in South Africa, who whistleblow on the corruption in police. And he was being interviewed by a television channel, and he said, if I die, hold Ramaphosa responsible. There's a case in Nigeria too, we see ongoing, of Nnamdi, who talk of the organ harvest and extrajudicial killing in Anambra State by the police. He had to run to Anambra, to the Republic of Benin. He was picked up by Interpol. And when he was brought back to Nigeria, he was alleged of hacking into somebody's account and stole 35 million. That is the reason why we must all understand this system, the management system. What are the concerns to be raised? When do you raise the concern? What are the procedures? It's so much important. And those are the things we will cover briefly before we zero it down to the selected countries of Nigeria and Botswana. We have 8 concerns to raise a concern about, to whistleblow about. Conduct as an offense or a breach of law, disclosure related to miscarriages of justice, health and safety risks, including risks to the public as well as to other staff, damage to the environment, the one that we are familiar with and we always think that's the only thing, the unauthorized use of public funds. That's the most popular of all the concerns we can raise. Then the possible fraud and corruption, which is the center of this webinar. Sexual or physical abuse is a concern that we can whistleblow about, and other unethical conduct. What are the steps when we are raising concern? Number 1 step is to raise your concern informally with the individual concerned or the manager of the company. Why do we need to do this? It might help us to extract more facts. So in the course of the webinar, we see the reason why we have to gather sufficient, not as a lawyer, but not to avoid trouble. We need to gather sufficient evidence. Indeed, our whistleblowing, our raising concern must be based on evidence because it must be made in good faith. So we need to raise it formally. We are not witch hunting. Let him know. Who knows? There may be remedy. So we raise concern informally with the individual. When he yield, if step 1 work, it doesn't fail, then we don't need to go to step 2. Step 2 is after we have raised concern with the individual concern informally, let's go back and read our whistleblowing policy and procedure before we raise concern at all. Because whatever concern we are raising, it must be in line with the whistleblowing policy. We must study the whistleblowing policy. We must study the legislation that has to do with whistleblowing. Because whatever concern we are raising must be in line with the policy and legislation. Otherwise, we run into trouble. And we will do this at earliest opportunity. Before we raise concern, we must make clear that you are raising it in line with whistleblowing policy. That's why you must read it and the relevant act. Read it, master it, and it must be in line. What should be our focus when we are raising concern? 3 major things. Ensure you include as much evidence and factual information as possible. That is why we say you can still raise this concern informally with the person involved or a manager within the organization. It will avoid you, it will have opportunity to gather more information, gather more evidence. And when you are raising concern, you must be specific about these 4 things. The date and the time. Which date, what time. What is the concern? What happened? And the order of event. What is the concern all about? Who was involved? Do we have any witnesses? When you are reporting, the reporting channels are actually in most countries, at least the country that have dedicated whistleblower protection act. The channel to raise are defined, the procedure to raise are defined. We'll examine all these things when we get there into specific Africa as a specific country in Africa. You can make the report within the workplace to competent authority and to external parties or public. What are the forms? We have 3 forms of reporting. It could be open reporting, it could be confidential reporting, it could be anonymous reporting. What are the differences? What is open reporting? Reporter give their name with consent that is reviewed. This is my name. Peter is my name, and I'm reporting this case. You can give my name. It is always easier and quicker. That's the advantage. That's the beauty. Easier and quicker for the organization to understand and address. And again, you have minimized the mistrust. In confidential reporting, you are the reporter say that, oh, this is my name, but don't give it except I ask you to do so. It must be with my explicit consent. But in all fairness, confidence is seen as cornerstone for internal complaint mechanism, as it protects reporter from potential retaliation. And the third one is anonymous reporting. Reporter refuse to give their name. You ask me, how can he refuse to give his name? If he phone in, if he does, you can. We will cover this one under different acts in Nigeria and Botswana. May I even say from the world, in Africa, Botswana as of today is the pace setter in the area of whistleblowing protection. They set the pace. They are ahead of every other country in Africa. In anonymous reporting, reporters refuse to give their names. But we don't always fall in love with it because a large detail, which could have allowed tracing disclosure back to the reporter. And again, it makes feedback on finding and any action taken difficult. But even when you want to, when the anonymous is allowed, there must be limitation to which this can be allowed. And it's not even the preferred option. Let's look at Africa, which is our concern today. The one we have just said, just to lay the background. It's just because of. Let's concentrate on the one that is our business, the African country as a case study. African continent. Whistleblowing and raising concern in Africa can be discussed along the two lines. The first one is the category of country which, with respect to whistleblower protection laws, and you can categorize them into two. The other one is the commonality in whistleblowing protection law. What do they have in common? The whistleblower protection laws in African countries, what do they have? And they have 4 issues in common. Let's look at the category of country with respect to whistleblower protection laws. The first one are the countries that have dedicated whistleblower protection. And you can see there are few. Botswana, Ethiopia, and Ghana. Nigeria is not even in the one that dedicated whistleblower. They have dedicated whistleblower protection law. It's not scattered into, the profit is not made for it in other laws. So the second one is the one where you have the whistleblower protection under provision under other laws. You have Nigeria, Kenya, Mauritius, Mozambique, South Africa. I know you want to ask me what about other countries. I will leave that one to you to research into. But this one, the one, they have whistleblower protection, but they are under other laws, not dedicated whistleblower, not whistleblower protection law, dedicated whistleblower protection law. What do they have in common? Whether it's under the, whether it is provided for under other laws, or there are dedicated laws for it. What do they have in common? They have the following in common: the scope of protection, that who is protected, the fact triggering the protection, that is the approaches, what constitutes protection disclosure, the implications. And then you have last one, the element of protection. What are the elements? Those are the 3 things they have in common, all the laws, whether dedicated or the provision, but it's richer from country to country. And that's why we've selected the Botswana and then used Nigeria as another example, essentially because Nigeria has got this one tested. They have got a case recorded on it. Element of protection could include protection from retaliation, reporting channels, anonymity, enforcement of mechanism, incentive and financial awards. These are the things that make people to jump at whistleblowing sometimes, raising concern. They concentrate much on incentive and financial rewards. They want to benefit, not as if they are doing it with all heart. And some of them run into trouble because of the award attached to it. Then the notion of good faith, you find it there, because it can't be in bad faith. If the complaint is made, if the concern is raised in bad faith, it's over the bar. That's a foul. Let's look at Botswana and Nigeria as selected African country. And when we are discussing these two countries, we'll be looking at these 7 things. How does Botswana define whistleblower in its act? What are the institutions? The same thing applies to Nigeria. What are the institutions that can authorize a person to receive a disclosure of impropriety in Botswana and Nigeria? Which legislation govern protection of whistleblower in Botswana and in Nigeria? How is a whistleblower protected in terms of this legislation in place? What is the procedure prescribed by legislation for an employee to make a protected disclosure? For it to be a protected disclosure, a whistleblower must, or concerned raiser must raise it in line with the procedure prescribed by legislation. And the reporting obligations on person to report, that's where my colleagues are concerned mostly. Your table can send you to jail. Yes. 2 years term, 1 year term, 3 million Botswana pounds. When you have the obligation to report irregular conduct and you fail to do so. And we're running up by looking at the country experience, the experience in Botswana, the experience in Nigeria. Case study of Botswana. What is the definition of a whistleblower in Botswana? It's defined by Whistleblowing Act number 9 of 2016, section 2. And define a whistleblower as a person who makes disclosure of impropriety that is protected in terms of the law. And this disclosure of impropriety is protected only if and only if it is made in good faith, the whistleblower reasonably believes that the disclosure and allegation contained in the disclosure is substantially true. And the disclosure is made to an authorized person. It becomes mere noise and rumor if it's not to an authorized person. What are the institutions in Botswana that can authorize persons to receive disclosure of impropriety? We have 10 of them. We have the Director of Corruption and Economic Crime, which is more or less similar to our own in Nigeria. When we get there, I will mention it for you. Then you have the Auditor General, you have the Directorate of Intelligence and Security, you have Botswana Police Service, you have Ombudsman, you have Botswana Unified Revenue Service, the Financial Intelligence Agency, the Competition Authority, the Botswana Defense Force, the Botswana Prison Services. All these can authorize persons to receive a disclosure of impropriety. What are the sets of legislation that protect whistleblowers in Botswana? You have 5 of them. The Constitution of the Republic of Botswana, the Whistleblowing Act of 2016, because that's why I say they are the pace setter as far as whistleblowing protection is concerned in Africa. There is a dedicated act for it, and that is Whistleblowing Act of 2016. Elaborate and protect the whistleblower. So there is nothing to fear if there is a misconduct that needs to be reported and you understand this, you are well protected. The third one is the Corruption and Economic Crime Act. And you have a similar thing to that one. The Employment Act, the Financial Intelligence Act. Now, how is whistleblower protected in terms of this legislation? Under Constitution, how is a whistleblower protected? Under Whistleblowing Act, how is a whistleblower protected? Under Corruption and Economic Crimes Act, how is it protected? By Constitution, Section 12, subsection 1 of the Constitution of Botswana protect the fundamental right to freedom of expression. And a whistleblower can rely on this one while raising concern. Under the Whistleblowing Act, we have Section 14, Section 15, Section 16. These sections protected the whistleblower and were protected. When I say protected, for example, Section 14 of the Act protect the whistleblower for the disclosure of impropriety. A whistleblower shall not, by stating that a whistleblower shall not be subjected to victimization by their employer, a fellow employee of another person, or another person for making a disclosure. An employer cannot do that one. A fellow employee cannot do that one. Another person can, as long as it's because of whistleblowing. Section 15 of the Act protects the whistleblower against civil and criminal action. You can't sue a whistleblower because he whistleblow on for criminal or civil action. Based on that one, not on other issues, based on whistleblowing. And Section 16 provides protective measures to whistleblower by ensuring that a provision in a contract of employment between an employer and employee is void, null and void, if in the letter of employment it prevents an employee from making the disclosure of impropriety, if it includes an employee from making a complaint about victimization, if that letter of contract prevents an employee from bringing an action in court or before an institution to claim relief or remedy in respect of victimization, any letter containing this is null, is void. Under the Corruption and Economic Crime Acts of 1994, Section 45 offers protection to whistleblower by conferring anonymity on whistleblower. You can raise concern anonymously. It can be anonymous reporting. It confer that privilege on them, so that you may be even protected by not disclosing who you are. And again, by prohibiting the obligation of a witness in a trial in respect of an offense under CSA, that is Corruption and Economic Crime Acts, to disclose the name or address of any informer or state any matter which might lead to their discovery is not allowed. Allowing the court to conceal or obliterate any passages and mentions in any documentary evidence in proceeding under CSA in which an informer is named or described, or which might lead to their discovery. Once that name is mentioned, another party can discover that this is the name of the person, the informer, it must be obliterated. Employment Act of Botswana do fantastic in protecting the whistleblower. In fact, you will have thought that probably the act is passed to protect the whistleblower. The Employment Act, Section 13A and 23C protect the whistleblower in the following way. It provides that neither the commissioner nor any labor officer shall, in pursuance of the Employment Act, reveal the source of any complaint about a defect or breach of the law, or give any intimation to an employer that a visit or inspection was made in consequence of such complaint. No. And Section 23 provides that an employer shall not terminate employment contract on the ground, on the basis that the employee made in good faith a complaint or participated in proceeding against the employer involving the alleged violation of any law. You can see, dear colleague, particularly my colleague from Botswana, how well you are protected as an employee and as a worker. The fifth one that protects the whistleblower is the Financial Intelligence Act, number 2 of 2022, FIA. Section 47, subsection 1 of the Act provides for indemnity of a person who reports a suspicious transaction from civil or criminal liability. If the report was made in good faith, whether or not an investigation finds the suspicion well-founded, it doesn't matter whether it's well-founded at the end of the day or not, but it's indemnified by virtue of this financial. What we'll be discussing, who are protected under Financial Intelligence Act, have to do with finances, financial matters. It provides that no evidence about the identity of the person who has made, initiated, or contributed a report of a suspicious transaction, or who has furnished additional information concerning the report is admissible as evidence in court proceeding, unless the person testifies as part of the proceeding. So you can't use that one, except he appears in the court, but you cannot use his identity to take him, as admissible evidence in the court proceeding. The Whistleblower Act, what are the procedures The one we have just finished is how they are protected. What is the procedure prescribed? And this procedure must be followed strictly whenever we are raising concern. Failure to do it could make us to land in soup. We could be in soup. Section 9 of the Act prescribes the procedure for making disclosure. And the disclosure of impropriety may be made orally or in writing or even by digital communication. So if it's made orally, it's still valid, acceptable. In writing, okay. By digital communication, email, through website, still acceptable. A disclosure of impropriety shall contain, whether in writing, whether orally, shall contain as far as practicable the following. And that is the reason why we say sometimes it's always good to even approach informally the person involved, the person concerned when you are raising, because it can help you to gather more information. The full name and address and occupation of the whistleblower. Who are you, the whistleblower? The nature of the impropriety. What is the concern that you are raising? The name and particular of the person the allegation are leveled against. Who did what? This concern, now it has to do with fraud. Who committed the fraud? Who is the fraudster? It has to do with corruption. Who committed the corruption? The time and place of the alleged impropriety. Where did it happen? Where did it happen? All these are needed when you are disclosing the procedure to be followed. The full name and address, and description of any witness to the impropriety. Is there any witness? We are not saying that you should act as a lawyer, and we are not saying, but you see, you build your file from the word go because you don't know how far it will go. Whether the whistleblower has previously made a disclosure of the same impropriety on a previous occasion, and if so, about whom and to whom the disclosure was made. This must be stated is the procedure to be followed. It's defined by Whistleblowing Act. If the whistleblower is making an employment-related disclosure, and if the whistleblower remains in the same employment, are you still on the job? Are you still in that same workplace? Or you have left the place? When you are making disclosure that has to do with employment, your office, your workplace, then any other information that minister may prescribe. So it's not exhaustive. Minister may prescribe other information to be supplied. But this one must be followed strictly and produced when you are raising concern in Botswana. Now, under Financial Intelligence Act, what are the procedures? This one has to do with financial matter. And there are procedures when you are raising concern under the Financial Intelligence Act. Any suspicious transaction to be made must include the following. The identification of the customer, and that's why we say it has to do with financial. The identification, when I think financial is insurance company, banking industry, and all those kind of things. The identification of the customer and the other party to the transaction. Nature of the transaction, the amount of transaction, the circumstances giving rise to the suspicion, the business relationship of the customer to the person making the report. Who is that person to you? If the customer is an insider, whether they are still affiliated with the specified party. This must be stated as a procedure to be fulfilled under FIA. Any voluntary statement about the origin, source, or destination of the proceed, the impact of the suspicious transaction on the financial soundness of the special party. That is an area that's, well, it's not as critical as that. But what do we mean by impact? Like how many million, like how many billion has he stolen? The size of the fraud. So it's not as if the law demands too much from an individual that is raising concern. The names of all officers, employees, or agents dealing with the suspicious transactions. What are their names? Who are the employees or their agents? Under the Employment Act, there is a reporting obligation on persons. This is not if I like. This is not for financial reward. This is not whether you fear or you are afraid or you are not afraid. You fail to report irregular conduct under the Employment Act in Botswana, you are in trouble. And you say this one in Section 11 of Employment Act of Botswana, which provide that it is the duty of every labor officer or the Commissioner of Labor, any abuse is not specifically covered under the Employment Act, any other defect or omissions, whatever that is not specified, but you are seeing it as a misconduct, you are seeing it as wrongdoing, it must be brought. When you fail to bring it, you have access to it and you fail to bring it, you are already in trouble with yourself and with government. Failure to act attracts a fine not exceeding 1,500 Botswana pounds, or imprisonment of a term not exceeding 12 months or both. So you can pay for your failure to do that, to report, because you're under obligation to do so. Not if you like. Then this penalty can fall on you. Under the Financial Intelligence Act, who are under obligation to report irregular conduct? Section 38 of FIA places an obligation on certain professional and their institution to report to the Financial Intelligence Agency. So any suspicious financial transaction they observe in the execution of their professional duties, they are obliged, not if they lie, by virtue of Section 38 of Financial Intelligence Act. Now, Section 46 of the same Act specifies that failure of the party or institution, the institution or the party to report a suspicious transaction is liable to an administrative fine not exceeding 5 million Botswana pounds. You breathe in and breathe out. That's the fine for failure to carry out the obligation, or a suspension or revocation of their license or registration, or both penalty. You are out of business because you failed to do so. A member of senior management of a specific party or accountable institution who fails to comply with the anti-money laundering and counter financing of terrorism measure commit an offense under Section 48 of FIA and is liable to a fine not exceeding 250 Botswana pounds, or imprisonment for a time not exceeding 5 years, or both. I don't know which one is even suitable there. And it's not even your choice to determine. And Section 40 of the same Act, subsection 1 of it, covers general reporting of the agency. Any transaction they have reason to believe may be suspicious. Section 40, subsection 2 also provides that a person who accepts any payment in cash exceeding the amount prescribed or the equivalent in foreign currency shall report it to the Financial Intelligence Agency. Section 46, subsection 2 states that a person who fails to report under this section commits an offense and is liable to a fine not exceeding 3 million or imprisonment, 3 million Botswana pounds, or imprisonment for a time not exceeding 20 years, or both, for not reporting. Incidentally, Botswana is yet to record any decision by a court from any of the legislation applicable to whistleblower. All those legislation we have examined, 5 of them, very fantastic, very robust, the most robust in Africa, but they are yet to record any decision by a court from any of those legislation, whether Employment Act whether Financial Intelligence Act, whether it is Whistleblower Act of 2016. They are yet to record any decision, whereas Nigeria has been able to record a court decision on it. That's why the fact they don't have dedicated Whistleblower Protection Act. Let's go to Nigeria as a case study. But I can tell you categorically, even as in Nigeria, that we are far behind Botswana. Definition of a whistleblower, because there is no act in particular in place. It's just scanty definition here and there. One of central bank and the general definition. Central Bank of Nigeria guideline for whistleblowing in Nigeria banking industry, and you see, it's restricted to banking industry. I define whistleblower as any persons, including the employee, management, directors, depositors, service providers, creditors, another stakeholder of an institution who report any form of unethical behavior on dishonesty to the appropriate, whoever, you see, is elaborate, but it's restricted to the banking industry. But it defines whistleblower in that general or generic form: management, director, depositors, service providers, creditors, and other stakeholders. What are the government agencies that have issued whistleblowing guidelines in Nigeria? The Central Bank of Nigeria, the Budget and National Planning, particularly during the tenure of Kemi Adeosun as Minister of Finance. This was elaborate. In fact, when whistleblowing was made popular in Nigeria. Nigerian Pension Commission, very fantastic. In the whole, in Nigeria as of today, I think they are the leading lamp too. They are the pay setter in Nigeria, Nigerian Pension Commission. There are some things that the only thing that it has to do with pension matter, the pension fund custodian, the pension fund administrator, but they are far ahead in terms of the whistleblowing protection. Central bank anti-money laundering and combating the financing of terrorism. Nigerian Stock Exchange Rule Book 2015. All these are sectional whistleblower protection. The Nigerian Stock Exchange only cover those companies that are quoted in the stock market. The same thing with Security and Exchange Commission. What are the legislation? We have said there is no dedicated whistleblower protection act in Nigeria. The one that will have metamorphosed into it, the bill passed by National Assembly in Nigeria, but was not assented to, was not signed, so it didn't become acts. Is the Whistleblower Protection Bill of 2019, Public Interest Disclosure and Complaint Enactment Bill of 2021, Safeguarded Disclosure Whistleblower Special Provision. These are what would have been a dedicated Whistleblower Protection Act in Nigeria, but they didn't see the light of the day. So we have just 5 of them provisions under different acts to protect whistleblowers. The Corrupt Practices and Other Related Offences Act, the EFCC, Economic and Financial Crimes Commission Act, the Investment and Security Act, which has to do with capital market too, the Freedom of Information, that look at general too. Those are the ones that having provision. And when we look at them, you can, within your own mind, you can compare them with the case of Botswana, which we have discussed. So how is a whistleblower protected under those 5 acts we have mentioned or listed? Under the CPRO, the Corrupt Practices and Other Related Offences, how is whistleblower protected? Because the act prohibits and prescribes punishment for corrupt practice and related offenses, and it provides protection for persons who give information to the ICPC about an offense. If you give an information to ICPC for an offense, the Act protects the whistleblower, the person raising concern. The identity of the informant and everything contained in the relayed information may not be disclosed in public, except the trial judge or a defense lawyer in proceeding before a court or a tribunal. So whistleblower is protected. If any document or material given in evidence in proceeding before a court could potentially reveal the identity of the informant, the court should conceal or remove it, obliterate it, to protect the identity of the informant. This protect the whistleblower as against the fear people always. We have found out when people say that to whistleblow in Nigeria, you are gone. It's not in that context. It's because we are here to understand or to really, and that's why all of us here, participants, should give thanks to CIFA. We should give them kudos, we should clap for them. You give them a round of applause. Because the whole essence is to embolden us, to equip us, to embolden us, and to let us know that we have a duty, we have obligation. If truly we want our nations to grow, if truly we want our nation to become what we want it to be. So whistleblower is protected. The reason why people don't whistleblow in Nigeria is because they either being compromised or they are partaker in that corruption. Let's move ahead. The EFCC protected whistleblower. Officers of the EFCC cannot compel to disclose the source of their information or the identity of their informant, except by order of court. And under the Investment and Security Act, ISA gives an employee of a capital market operator or a public company the right to disclose any information connected with the activity of in his workplace, which tends to show that a criminal offense has been or is likely to be committed, or that a person has failed, is failing, or is likely to fail to comply with any legal obligation that is subject to. Under Investment and Security Act, is obligation and is protected, and the employer, the operator is protected to whistleblow. And again, it prescribes that no employer shall subject any employee to any detriment on the ground that the employee has made a disclosure in accordance with the provision of the ISA. Under the Freedom of Information Act, how is a whistleblower protected? In actual fact, the FOI Act was passed or enacted to make public the records and information more freely available, and to provide for public access to public records and information. So anyone can rely, and in actual fact, in the case of Yorùbá versus the Council of Yaba College of Technology, which we know we are going to round up our webinar this day. We will be able to get the gist here, because in that case, the Bureau will rely on EFCC Act and FOI Act, and in one the case is to protect serving public officers from the adverse consequences of disclosing certain kinds of official information. And Section 27 of the Act stipulates that no civil or criminal action will be taken against an officer or any public institution for disclosure made in good faith, pursuant to the Act. Under the Central Bank guideline, it mandates financial institutions under the supervision of CBN to put in place whistleblowing policy. If you Google it today for any bank in Nigeria, you will see the whistleblowing policy of all the banks is to make it public, both to their employee and even management and whoever care. That is the requirement. A whistleblower can disclose any information connected with the activities of a financial institution. It is to be made to either the relevant financial institution, the CBN, or any other appropriate agency. Financial institutions are required to treat all disclosure in a confidential manner to keep the identity of the whistleblower confidential. And no financial institution shall subject a whistleblower to any detrimental treatment on account of disclosure. The whistleblower is entitled to report any detrimental treatment to the CBN, and they will be entitled to compensation and or reinstatement for the detrimental treatment. I know my people in Nigeria who are particular will be saying, how possible? In Nigeria, all these are possible, and you are protected. You only shy of fear, you exercise fear unnecessarily. Let's go on. That's why I said you before that National Pension Commission is far ahead of others. Indeed, and we discover this one when we run through the remaining slides. The National Pension Commission whistleblowing guidelines state that the director, management, employee, and any other person have dealing with a personal fund, administrator, or pension fund custodian have a responsibility to report. It's a responsibility to report any breach of the Pension Act, codes, guidelines, rules, and regulations issued by the Commission. PFAs or PSC are required to undertake that any employee blowing the whistle on unethical or illegal activity will not be victimized in any way. It provides that a PFA, PSC shall not dismiss or suspend, fire or demote or redeploy a whistleblower without the consent of the NPC. You cannot. The PFA or PSC shall not deny the whistleblower any of its entitlement. Any salary review that will negatively affect the whistleblower must receive the NPC approval. A whistleblower is entitled to complain to the NPC about a detrimental action. The NPC can issue a letter of caution to the PFA or PSC and direct it to retract the action taken. You can see how well protected you are if you are in you are in pension sector in Nigeria. You are well protected to whistleblow, to raise concern. Under the CBN anti-monitoring, and this one concerns much of the CBN staff itself. You have up to this, the manuals is a guarantee that employee conduct the business in accordance with the relevant anti-money laundering laws. And report of violation or suspected violation of the manual shall be kept confidentially. Whistleblowers shall be protected by the bank if they are threatened. Employee who threaten whistleblower are to be disciplined in line with the CBN, Human Resources, Policy and Procedure Manual. Now, what is the procedure? Now that's why I said, let's compare Nigeria with Botswana and be the judge by ourselves. We have only a National Pension Commission whistleblowing guideline for pensions and SEC code for corporate governance for public company that actually state the procedure and not in elaborate form like that of Botswana. Like NPC, the National Pension Commission guidelines state that the disclosure must be in writing. So no oral disclosure is permitted or allowed. The whistleblower must set out the background and history of the concern, giving names, dates, places where possible. In Botswana, you won't see where possible. And even this law has to do just with pension sector, not with all other cases. And again, the reason why they are particularly concerned about the situation, if the whistleblower is unable to put their concern in writing, they may contact an appropriate officer of the NPC. The whistleblower is encouraged to put their names to the allegations. They are encouraged. That is not specific enough too, but that's their policy. The NPC will consider anonymous disclosure at its discretion. They are the one to determine whether you can make it anonymously or it must be open. Second, to stipulate the following, just two things. The company should have a whistleblowing policy. So you can Google it for most of the quoted company in the capital market. You'll see it in the whistleblowing policy is compulsory. Company should have a dedicated hotline or email system, which could be used anonymously to report on ethical practices. Now, is there any reporting obligation? In Botswana, we look at the Employment Act, we look at the Financial Intelligence Act, and those one specifically state the obligation. In Nigeria, it's only the NPC and the other, I've told you that the Nigeria Pension Commission is far ahead. They should clap for themselves. So the chief compliance officer has the obligation. The director, the management, the employee, and any other person involved in dealing with, they have the obligation. The guideline do not specify any consequences or any consequence for failing to make a disclosure. That's not complete. At least it's a little better. Reporting obligation as stated. Those are the two, the NPC and the CPRO. Under CPRO, Section 23 of CPRO imposes a duty on public officer to whom any gratification is given, offer, or promise in contravention of the act to report it. It must be reported. And let me chip in too, it's like our SCUM here, the SCUM that we they return on weekly basis to its department or EFEC in Nigeria. But under CPRO, it is obligatory. A public officer from whom gratification has been solicited or obtained has a duty to report. Failure to comply with this provision without reasonable excuse is an offense. But the penalty is just 100,000 naira, a prison term not exceeding 2 years. Under central bank, this is general true, and it requires financial to make following disclosure in their annual report. The annual report should contain disclosure of frauds and forgery, and any other matter not specifically mentioned, but which could affect the financial condition to the bank significantly. And that's a bank. Now, let's round up on the case study of Nigeria. Why Botswana has never recorded any case. Nigeria has recorded an interesting case, and that's the case between Ibirogba and the council, Yaba College of Technology, Lagos. Ibirogba, who was the claimant, was the bursar of the college. He disclosed to third party information that has to do with corruption and financial impropriety in that college. And now the rector has been mismanaging the fund of the college. The third party went ahead and lodged the petition with the EFCC. The college, the council set up a committee to investigate who could have done this. This wouldn't have been known to third party. There must be the hand of Esau in this one. So the subcommittee, they investigated it. They went down to Bossa that he was the one who had actually done that. And therefore, he was accused of gross misconduct of leaking official documents and bringing the college to disrepute. The claimant was suspended for 3 months and placed on half salary for the duration of the suspension. Again, the suspension was subsequently extended indefinitely, and the man went to court. The court found that the claimant's suspension was a reprisal for disclosing the information that led to the EFCC petition and violated the whistleblower protection contained in the EFCC Act and the FOI Act. The court therefore declared the suspension to be unlawful and set it aside. What are the takeaway? Our key takeaway. As public sector professional, we need skill to exercise professional judgment. Our application went to whistleblow. And that is the reason I keep on hammering that we owe it a duty to thank CIFA for this training. There's need for good knowledge of protection enjoyed under various legislation by whistleblowers. So nothing to fear, except to fear yourself. The need to make whistleblowing protection work in Africa is so critical to us if we want to grow, want to develop. Africa requires whistleblowing protection to curb corruption in Africa. And on this note, I sincerely thank you for listening.
Thank you so much, Peter. That was absolutely fascinating. So we don't have any questions. Let me just stop sharing that I can see you as well. We don't have any questions in the Q&A at the moment. So I'm going to take Chair's privilege and ask my questions, if that's all right. You spoke an awful lot about you spoke an awful lot about the protections for whistleblowers, which is absolutely fantastic. If there is sort of retaliation against a whistleblower, and not necessarily by an employer, but maybe by like an individual that's been affected, like if someone's blown a whistle and it's led to someone else being fined or whatever.
For example, like damages to environment. Damages to environment might not have something to do with the employer.
Yeah, something like that. So what happens if there's retaliation against the whistleblower, but it's not by an employer? Is there sort of protections for that?
The protection for in Botswana, the protection for the whistleblower under that circumstance is spelled out under Whistleblower Act of 2016. The Employment Act will not apply in that context.
Okay, I see.
It will now rely on Whistleblower Act 2016. And that will make him to be secure. When there is retaliation, the court will be there to defend him. But it will not be relying on Financial Intelligence Act. It will not be relying on Employment Act. It will not be relying on even corruption, whatever. So it depends. Like the case we have just, the case we have just examined now. It relies on two acts there. It relies on Economic and Financial Corruption Act. It relies on Freedom of Information Act to set aside whatever they have done to get out of that victimization. So it depends. That acts, it depends on the case. You can rely on 4 or 5 of the acts. You can rely on 1, but you still be safe.
So I found it interesting that was sort of no action in Botswana. Nothing. Sorry, I wrote it down, but I can't find it now. Nothing that's gone through the course in Botswana. That's right, isn't it? That's what
I guess I may not know. And the question I'll be asking too, could it be that the level of corruption is so low? Could it be that people have not been raising concern? But I think that will be left to researcher to find out.
Okay, fair enough. Do you think there's where there's a legal framework in place to support protection for whistleblowers? Have you seen any? Where I'm coming from is the work that we're doing on the corruption prevention program is actually quite cultural change rather than legislation and regulations. Have you come across it selfishly, because I'm trying to design an effective corruption prevention program? Have you come across any effective cultural change that's supported the legal frameworks that you've seen in place?
I hope we have participants from Botswana. Mm-hmm. If we have participants from Botswana and the key officer, they are public finance accountant, they will be of help to the country. That's why I keep on saying thank you to you in the course of the webinar. You have done greatly to organize this training. And if there's any participant, not only from Botswana, but particularly from Botswana now, they should be able to pick up 1 or 2 things that will help them and suggest to the government, and then rejudicate. You see, it has to do with the context of culture, the way you are saying it too. It's varying from place to place. But that will be their job. They are on the ground if they have participated and they love the country.
Do you know what? You're absolutely right. It's just the work that we've been doing to develop our corruption prevention programme. We've very much seen exactly what you've just said, that it does differ from place to place, and it depends on, like, for example, in England, if you're trying to reduce issues of corruption, or, you know, sleaze, as we prefer to call it, for me, it's tackling things like the old school networks and things like that, where actually I think, well, unless I'm very naive, I think a culture work that requires bribes to be paid, for example, is not where I live. However, there's definitely corruption, because it's just a different type. It's things like, you know, revolving doors in employment, and like I say, the old school network. So you're absolutely right. It very much differs from place to place in terms of what the underlying issues are, and therefore what the response needs to be. Yeah. One thing I picked up on very early in your presentation, I think, or very late, it's at the bottom of the page, I can't remember which page I used first, was about the important, you mentioned that there was one of the regulations requires public disclosure. I can't remember which one it is, but I just wanted you to pick your brain a little on that. What do you think it's important that there's public information available? Because what we've seen in our work is that transparency, where it's used appropriately, like you wouldn't want to sort of disclose information that you know, puts someone at risk, for example, or gives ideas to someone as to how to commit corruption effectively. You wouldn't want to disclose things like that. But where disclosure of information publicly is done appropriately, we've been finding out that people think that that's sensible, because the transparency helps shine a light on poor behavior and therefore remove it. What's your views on?
I guess you're having a question, but I'll ask you a question. Let me allow you to learn. It's like you're having the questions online. The where I refer to the public disclosure is when I was discussing the issue of Freedom of Information Act in Nigeria. And by that act, it's saying that if a public officer disclose an information that has to do with raising concern, not reckless information. You know, we listed the concerns. Those are the concerns. It's not the issue of you snatch my wife and I now raising concern of snatching my wife. We listed 8 of those concerns that you can raise. If it is raised in line with those concerns, in some places it might be elongated than that. That does not mean it's a succeed, but they are the critical one.
Yeah.
You are protected. That is not reckless or release information to the public in that context. And that person will be protected. Because the whole essence is that it's preventing misconduct, it's preventing corruption. And that one, I mean, it will rely on all those acts. Why you disclose that one, no matter how confidential that information could be.
Yeah, fabulous. One of our attendees has asked a question, actually. I'll put this one to you. I'll just read it out. What are the protections provided for the whistleblowers who report against the top is known to them?
Come again.
The protection, so if someone reports against like senior leaders, what protections are provided for the whistleblower in that situation? Oh,
great. That will be in terms of workplace. That will be in terms of workplace. Yeah. Now I have Alice or Lorraine as my boss, and I've seen them doing wrong thing, misconduct, or involving corruption, and I want to report. That's why we first look at this management of whistleblowing system. The whistleblowing policy of that organization will have stated the procedure, the channel. Are you with me?
Yeah.
There must be whistleblowing policy of an organization. Like CIFA now will have whistleblowing policy.
Absolutely, yeah.
The whistleblowing policy will have stated the procedure, the reporting channel, and the forms, could it be made anonymously? Could it be made in open form? Could it be made confidentially? Now, if the policy allow me to make anonymous reporting, and I want to report Lorraine to our big boss, I don't need to put my name. So as for him to find out, I'm protected. Except my boss went ahead to say that kind of a thing. And if he went ahead to release that information, I'm protected under Whistleblower Act. Because I'm just doing what the act asked me to do. So now, if I followed the procedure I've presented in the form it should be presented, then I'm safe.
That's a good point.
What we are even saying is that it's not as if there will be no retaliation. You know, we'll be missing if we think that there will be no retaliation if they know that we are the one who reported. There will be, but we are saying you are protected.
Yeah, that's an important distinction, actually. Yeah, and you're right. The aspect of anonymous reporting will very much help, I suppose, to avoid the retaliation in the first place. They don't know who's made the report. That's yeah, an important distinction and an important point, I would suggest. Yeah. One thing that occurred to me very early in the presentation was that in terms of the order of how you approach a whistleblowing incident, I think it was important, like you very much said, follow procedures, follow the regulations, because one of the things that I thought of is I used to be an auditor, and where you were suggesting about the informal discussion, so start off with an informal discussion, and then if that doesn't get you anywhere, move on to the formal procedures. Are there any situations in which you might avoid that? For example, if you're worried about tipping off, like as a former auditor, we had to. I never, thankfully, I never was in the position where I had to read the regulations properly myself, because I never found or suspected something like money laundering. But it was always drilled into us: avoid tipping off. Is that something that, like you said, follow the regulations? Is that something that would, if I followed the regulations, I'd be more likely to see?
If we follow the legislation, we will be more, we will be safer. In this context that where the legislation permit me to make anonymous, and I know my life, that's why I said it's because I was trying to manage the time. We will have flagged the video of the lady in South Africa. He was really shouting, if I die, hold Ramaphosa responsible. And the case I referred to for you too in Nigeria is still on in Anambra State in Nigeria. Yeah. The guy, Eme Namdi, he was IT consultant to police in Anambra. So he had privilege to see what was going on there. And he reported it. Extrajudicial killing and organ harvesting. When he was harassed, well, this had to do with police. So he had to flee the country to Republic of Benin. They still look for him and pick him up with Interpol in Republic of Benin. And by the time they brought him back to Nigeria, they brushed aside the case of whistleblowing. They said he hacked somebody's account and stole 35 million naira and took him to court. Those are the things whistleblowers suffer. But not that there will be no harassment. If you say there will be no harassment for whistleblower, if they are aware of it, if not anonymous, or for like the Birogba case we have just stated, they set up committee. This information wouldn't have gone out of this place, except there's an internal person.
Yeah. And
they discover, it's not third party telling them that it was the bosser. It was their own investigation that this information is so I mean, it's not what anybody can just have access to. And they zero it down to the bosser. When they are zero it down to the bosser, that is when they dealt with him. But he was awful because he could rely on those acts that protect him as whistleblower. So there'll be harassment, there'll be retaliation, there'll be all those kind of things. But we are saying that there's nothing to fear as long as you follow the procedure, you follow the reporting form, you follow all those things that you should do. And you are doing within your conscience or because your job demands it. If your job demands, you have no option. If I'm just external to it, I may not bother. But if your table, your job, you are obligated to do so, then you are taking two risks. Because if you don't whistleblow, when it backfire, you still be penalized on the other side. That will freezing or fine of 3 million Botswana pounds.
Of course, yeah, of course. I find it fascinating that you'd worked as was it the monitor on the case that you'd presented to us last? Was there any lessons that you learned from that you could possibly expand on, or any best practice in terms of sort of treatment of whistleblowers or stopping bad practice in the first place? What sort of lessons did you learn from that you've personally taken forward that we might learn from?
All right, two sides. Lesson for the whistleblower and the lesson for the government. Lesson for the government is that they have to really work on whistleblowing protection act, a whistleblower protection act in Nigeria. We don't have sophisticated enough provision in all those scattered acts here and there. And that's why it's relying on the generic one, FOI Act and EFCC. Now, so government should work fast, essentially the new government we have, to ensure there is Whistleblower Protection Act in Nigeria, dedicated one. That's the lesson for the government. And if need be to the one that is existing now, that is scattered under provision here and there, should be rejuvenated and invigorated on the part of all of us who are professional and who has the obligation to report concern. We could see that even though a birogba, the bosser, passes to the third party, not by himself, and maybe probably too, it might be amount to the fact that there is no procedure stated because there is no dedicated whatever. But for those of us who are in Botswana, who are in Ghana, where they are dedicated, let's be sure that these procedures and the legislation we study, we master it, like as we want to do exam. So that when we are raising concern, we follow it strictly. It will save us some hassles. It will save us. There are some that will not degenerate to the level of even anybody knowing about it if you follow the procedure. If I am allowed to do it anonymously, why should I'm allowed. So if we follow those legislation, we follow the policy of the company and all those things, I think we'll be safe in doing our job. Those are the two lessons. The lesson for the government, if there's anyone who is here, who is a participant and he work for government, that's a lesson. And the one for all of us who are obligated by virtue of our job to disclose.
Fabulous. Thank you very much. We've only got sort of a couple of minutes left. Let me just see. I don't think we've got any more questions in from the participants. So there's just a final call. If you do have a question, get it in like now. Peter, thank you so much for your time. We've kind of run out of time almost. I'll just check the Q&A before I say goodbye to you. But yeah, we've kind of run out of time. Thank you so much for your session. It's given me a lot of food for thought, certainly in terms of appropriate legislative framework and regulations and things like this that will very much inform what we're doing with our corruption prevention plan. And yeah, thank you for your insight and knowledge in today's session. And yeah, have you got any final thoughts for us? Just check if there's any Q&A. No questions coming in from the participants. Is there anything you'd like to say to as a final thought for us, Peter?
No question.
No further questions. So if
How many participants do we have?
Pardon?
How many participants do we have?
At the moment, we've got 3 participants still with us, and of course, because the recording, the session's been recorded, however many in the future, we'll watch the. I believe they put the recordings on YouTube, I believe. So anyone who's not been able to join us live today will, I'm sure, get the link to the recording and watch us in the future. And of course, you put your email address up earlier. Yes, if there's anyone that needs to contact you, I'm sure they will. So thank you so much, Peter. Thank you to our participants for joining us today.
As you really sincerely express my gratitude to you.
No, not at all. Not at all.
To have the opportunity to work with you and be a facilitator for this program. Not
at all. It's been absolutely fantastic to learn from you, and thank you from the participants and from all of us here at CIPFA. And on that note, I think we can draw today's presentation to an end. Thank you, Peter. Thank you for those attending, and please do come to any of our future events. It would be lovely to see you on our webinar series. Thank you. Bye.
Bye.